Chief Justice Martha Koome has issued guidelines barring lawyers from commenting on the merits or demerits of presidential election petitions during the period of their hearing and determination. In amended Supreme Court presidential election petition rules, Koome says discussing matters actively before the apex court would be prejudicial and contemptuous. And as Francis Gashuri reports, the Chief Justice's directives emanate from a flurry of social media posts during the Supreme Court hearings of the Building Bridges Initiative Appeal, BBI, where 3 lawyers were cited by the court for disorderly conduct.
As the country prepares to head to the ballot in 76 days in what is shaping up into a fierce Kenyatta succession race, the possibility of that contest ending up at the Supreme Court is alive. Chief Justice Martha Koome, who is also the president of the Supreme Court that has exclusive jurisdiction on presidential election petitions, has put on notice lawyers and litigants who would want to prosecute such matters in the court of public opinion. Directives contained in a special issue of the Kenya Gazette dated 5th of May 2022, barring litigants in the presidential election petitions and their advocates from expressing their opinion on the merits and demerits of such matters, or even predicting outcomes of such petitions until the apex court has rendered its verdict on the presidential poll outcome. Any breach of the amended Supreme Court rules on presidential election petitions would amount to contempt of court, according to the Chief Justice. Koome picking it up from where she left in March after citing lawyers who took to social media to prosecute the BBI appeal that was before the country's 7 top judges.
The contents of those social media commentaries were, in our view, meant to influence, intimidate, or scandalize the court. This unfortunate practice is emerging, and unless it is checked, it will erode the confidence and the dignity of the courts. It would also amount to unprofessional conduct, especially by counsel appearing in this matter, and even counsel who are not in this matter but know very well that they cannot comment on a matter that is pending judgment.
That time, the Chief Justice trained her guns on former Law Society of Kenya President Nelson Harvey, Senior Counsel Ahmed Nasir Abdullahi, and lawyer Esther Ngawa for discussing the BBI matter on Twitter.
For counsel to appear before the apex court, then proceed to hurl unnecessary diatribe, insults, and speculations on a pending judgment amounts to unethical conduct on the part of the counsel. The use of social media to disparage the court with the intention of lowering the dignity and the authority of the court or influencing the outcome of the case pending before the court is a trespass on the bounds of legitimate advocacy and moves to the realm of professionalism to professional misconduct.
Article 140 of the Constitution allows persons dissatisfied with the presidential election results to file petitions in the Supreme Court, challenging the election of the president-elect within 7 days of the date of declaration of the results. The Supreme Court has to within 14 days hear and determine such petitions, and its decision shall be final. If the Supreme Court determines the election of the president-elect to be invalid, a fresh election shall be held within 60 days of the determination. Francis Gashuri, Citizen TV.